Hi everyone, Dave Sugden of Evidence at Trial. Based on a request on our YouTube channel, we're going to talk today about the admissibility of medical records. And this is a great topic because it covers so many evidentiary issues. And as we get better at medical records, we'll also get better at other business records or organizational records. And so let's get into it. And first, medical records, they can seem tricky. We can have this perfect medical record. It can look all official. It can come by a subpoena with a fancy custodian of records declaration, and we're in trial, and all of a sudden we go to have it admitted and we get carpet bombed with objections. It's relevance, foundation, hearsay, 352, 403, and it seems like the only thing missing is a partridge in a pear tree. And so what are we to do? Now, when it comes to medical records, it's important that we realize there's not some special category in the evidence code that talks about medical records. Instead, what we're talking about are writings. And based on the case, we then apply the evidence rule to the writings to see if they're admissible or objectionable, if we're the ones that are opposing the admissibility. And so to get into it, let's consider a hypothetical. Let's assume we have a medical record, and that medical record provides that the patient's name is John Doe. And John Doe filled out the patient history wherein Mr. Doe wrote, "My boss punched me in the nose and I can't breathe. My boss is the worst. Bad temper." Then we have the doctor's note. And the doctor's note says patient's nose was broken. Patient said he always thought his nose was too big. To improve airflow and improve patient's look, performed nose job. So, is this document admissible? Is this medical record admissible? Well, we first have to ask ourselves is, what's the case? What's the case about? Why is it being admitted? Now, let's suppose this is not your typical personal injury or medical malpractice case. Medical records come up in all sorts of cases. So instead, let's assume this is an employment case, and Mr. Doe is alleging constructive termination. He's saying, I can't go back to work because my boss punched me in the nose, and he's always mean. And so first, we'll ask ourselves, is this medical record relevant? In this case, it sure is, because in the case we have Mr. Doe alleging that his boss is mean, that his boss punched him in the nose, and we have a letter or a medical record corroborating that testimony. And so Mr. Doe's lawyer will argue, yes, this has a tendency in reason to prove the allegations that Mr. Doe is making. Okay, fine. Next, is there an adequate foundation? And we see again in Evidence Code section 1400 and in Federal Rule of Evidence 901, the rule for foundation. And what that requires is that Mr. Doe's lawyers, as the proponent of the writing, they have to introduce evidence sufficient to sustain a finding that the writing is what the proponent of the evidence claims it is. Here, Mr. Doe's lawyers have a number of ways they can authenticate it. They could have Mr. Doe himself say, look, this is my handwriting. This is a document that I filled out when I got to the hospital. So the next issue is, do we have a hearsay problem? Now, we have the statement by Mr. Doe, and Mr. Doe wants to introduce it for what purpose? To prove that his boss is mean, to prove that his boss punched him in the nose. So we've got hearsay. How can Mr. Doe's lawyers get around it? Well, there can be a temptation for Mr. Doe's lawyers to say, well, this is a business record. It's a very official looking hospital record. But before we go there, let's look at the elements of the business records exception. And we see that in California in section 1271 and 72 of the Evidence Code and Rule 803, subdivision 5 and 6 in the federal rules. And in section 1271, what it says is that evidence of a writing made as a record of an act, condition, or event is not made inadmissible by the hearsay rule when offered to prove the act, condition, or event if A, the writing was made in the regular course of a business, B, the writing was made at or near the time of the act, condition, or event, C, the custodian or other qualified witness testifies to its identity and the mode of its preparation, and D, the sources of information and method and time of preparation were such as to indicate its trustworthiness. Now here, Mr. Doe has a problem, because although this was filled out at the hospital, it does not record an act, condition, or event by the hospital. Instead, it's an act, condition, or event that Mr. Doe is memorializing in a hospital record. And so it's much different from a hospital employee observing an act, condition, or event and making a record of it. These are events that were recorded by Mr. Doe. And so the defense would argue, no, the source and method of preparation does not indicate trustworthiness, and therefore it's not a business record for this purpose. So what are Mr. Doe's lawyers to do? They'll remember the state of mind exception, and they'll look at that and think, oh, this is a way to get that medical record admitted into evidence. But again, let's look at the actual language of the statute. And we see in section 1250, it says in subdivision A, subject to section 1252, evidence of a statement of the declarant's then existing state of mind, emotion, or physical sensation, including a statement of intent, plan, motive, design, mental feeling, pain, or bodily health is not made inadmissible by the hearsay rule when 1. The evidence is offered to prove the declarant's state of mind, emotion, or physical sensation at that time or at any other time when it is itself an issue in the action, or 2. The evidence is offered to prove or explain acts or conduct of the declarant, and B, this section does not make admissible evidence of a statement of memory or belief to prove the fact remembered or believed. So again, Mr. Doe's lawyers will have a problem, because in terms of what the statement says, the statement, "my nose is broken," that might be okay because it shows his then physical sensation. But in terms of why it's being offered to prove anything, what Mr. Doe's lawyers want to do is offer this to prove something about Mr. Doe's boss, that he punched him in the nose, that he is mean. But when you look at section 1250, what it says is these statements can be admitted to prove the conduct of the declarant. You can't be offering it to prove the conduct of someone else. And so, again, Mr. Doe would have a hard time getting this medical record admitted to prove the hearsay statement about what his boss did. Now, these are not the issues you'll always run into when it comes to medical records, but it shows that when we're encountering medical records, we don't want to think, oh, it's some special category that has a set of rules we have to follow. Instead, we go through the analysis that we would otherwise go to with any writing. So there it is, medical records. They're not a special category, but instead consider them writings and go through the same evidentiary analysis we always do when it comes to writing. Folks, I hope this was helpful. If it was, please download, rate, like, subscribe to our YouTube channel. If you have a topic that you want covered, like this one, send a comment in the YouTube channel and I will cover it in an upcoming video. For a really deep dive on all of these evidence issues, check out evidenceattrial.com and check out our online courses on demand. Thanks for watching.